Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the First Amendment, filming the police, and obstructing, and is brought to us by Sacramento Community Watch's channel. Be sure to check out the description below and give them the credit that they deserve. On the evening of August 22nd, 2023, the owner of the Sacramento Community Watch YouTube channel, who we will refer to as Mr. England, was walking in downtown Reno, Nevada, when he began to film a police investigation conducted by officers with the Reno Police Department, including Officer Gaucher and Officer Hoyt. Mr. England filmed the first part of the encounter, and the remainder of the interaction was captured on Officer Hoyt's body camera.
Ladies and gentlemen, thank you for joining the Sacramento Community Watch. We are in the city of Reno, Nevada, right off of West 2nd Street and North Virginia Street. Looks like we have Reno PD, multiple vehicles. Of course, we're going to walk up and see what's going on. First vehicle on the scene, 171. 210-371. Vehicle is going to be occupied one. Hello, how's it going, Gaudier? Pretty good, man. What's going on out here? It's going to be additional vehicle 072 200-272. It's going to also be occupied one time. Hey, how you doing? Yeah, what's going on out here? Nothing? Excuse me? Step away from your vehicle. Okay, this is our vehicle, actually. The city's vehicle. Okay? Also, when you're dealing with public, I'm recording for my safety as well as yours. This is Officer Hoyt with the Reno PD. How you doing?
Is there something I can help you with?
No, you jumped out your vehicle.
Yeah.
I mean, I didn't.
Why are you interfering with our investigation?
Interfering? That's a physical thing. I'm walking on a public sidewalk, recording you during the course of your duties. What are you talking about?
Place your hands behind your back.
Okay.
Officer Hoyt places Mr. England in handcuffs and stops his live stream. As we have discussed many times here on ATA, courts have repeatedly held that filming the police in public is protected by the First Amendment. In the 1995 case of Fordyce versus Seattle, the Ninth Circuit Court of Appeals, which has jurisdiction over Nevada, held that an individual videotaping and audio recording people on public streets had a, quote, First Amendment right to film matters of public interest. Similarly, in the 2018 case of Askins versus U.S. Department of Homeland Security, the Ninth Circuit determined that this right included, now quoting, the right to record law enforcement officers engaged in the exercise of their official duties in public places, noting that, now quoting again, the government's ability to regulate speech in a traditional public forum, such as a street, sidewalk, or park, is sharply circumscribed. Nevada state law also protects the right to film police officers, with Section 171.1233 of the Nevada Revised Statute stating that, quote, a person who is not under arrest or in the custody of a peace officer may record a law enforcement activity and maintain custody and control of that recording and any property or instruments used by the person to record a law enforcement activity. The statute also prohibits peace officers from interfering with an individual's recording of a law enforcement activity by, now quoting, intentionally preventing or attempt to prevent the person from recording a law enforcement activity, threatening the person for recording a law enforcement activity, commanding that the person cease recording a law enforcement activity when the person was nevertheless authorized by law to record the law enforcement activity, stopping, seizing, or searching the person because he or she recorded a law enforcement activity, or unlawfully seizing property or instruments used by the person to record a law enforcement activity, unlawfully destroying or seizing any recorded image of a law enforcement activity, or copying such a recording of a law enforcement activity without the consent of the person who recorded it, or obtaining approval from an appropriate court. However, it should be noted that the statute also states that, quote, this subsection must not be construed to authorize a person to engage in actions that interfere with or obstruct a law enforcement activity or otherwise violate any other law in an effort to record a law enforcement activity. Accordingly, it is likely that a court would find that Officer Hoyt's conduct in ordering Mr. England to step away from the vehicle, detaining him, and stopping the live stream violated both the First Amendment and the Nevada statute, unless Mr. England's filming was interfering with or obstructing a law enforcement activity.
Yeah, Charles 354. I don't want to front of Nevada. Madden.
This is
Can I help you with,
Officer
sir?
Hoyt with the Reno PD. How you doing?
Is there something I can help you with?
No, you jumped out your vehicle.
Yeah.
I mean, I didn't
Why are you interfering with our investigation?
interfering.
Yeah.
That's a physical thing. I'm walking on a public sidewalk reporting you
is there something I can
during
help
the
you
course of your duties. What are you talking about?
Go ahead and place your hands behind your back.
Okay. It's live streaming too, by the way. So this is
Put your hands behind your
this is
back.
the worst mistake you could ever make. I'm conducting First Amendment investigation on a public sidewalk. This is not a crime scene. You don't have crime scene paper. This is your mistake. And I want to speak to your watch commander too as well. So you might as well roll your lieutenant out. Thank you, sir. That was a horrible mistake. Why would you do that? I'm recording on a public sidewalk. There's no tape up, and there's other people walking on the sidewalk. Why would you do this? I need to speak to your lieutenant, please.
Doesn't work like that.
I am live.
Do you have anything in your pockets that can poke me, hurt me, or
I
stick me?
don't condone any searches or seizures.
I didn't ask you if you condoned any
in my pocket
searches and
that's gonna
seizures.
poke or stick me. This is a horrible mistake, dude. Horrible. Horrible. So now the officer's checking me.
Who are you talking to?
My live stream.
I stopped it.
Why would you stop you stopped my live stream? Wow.
All right, well, take a
Violation
seat.
of my rights. Wow. I can't believe you did that, dude.
Officer Hoyt informs Mr. England he is being charged with obstructing an officer because he refused to walk away from his vehicle while he was having a quote-unquote private conversation and refused to sit on the ground after he had been handcuffed. Section 199.280 of the Nevada Revised Statutes states that, quote, a person who willfully resists, delays, or obstructs a public officer in discharging or attempting to discharge any legal duty of his or her office shall be punished. Similarly, Section 197.190 of the Revised Statutes, which codifies the offense of obstructing a public officer, states that, quote, every person who shall willfully hinder, delay, or obstruct any public officer in the discharge of official powers or duties shall be guilty of a misdemeanor. In the 2024 case of Wilson versus the First Judicial District Court of the state, the Court of Appeals of Nevada held that Section 197.190 did not require the use of force or violence, and that, now quoting from that case, a person's action, e.g. blocking the path of an officer, or inaction, e.g. refusing to obey a lawful order, may constitute physical conduct that hinders, delays, or obstructs an officer. However, in the 2023 case of U.S. versus Garcia, the U.S. District Court for the District of Nevada determined that the lawfulness of an officer's conduct is an essential element of Section 199.280, and that, accordingly, when officers lacked reasonable suspicion to detain a citizen, they were not carrying out a lawful duty when they detained him, and the citizen, therefore, could not be arrested for resisting for his actions during that detention. Likewise, in the 2023 case of Bernal versus Sacramento County Sheriff's Department, the Ninth Circuit Court of Appeals concluded that, quote, verbally challenging and recording officers are not illegal actions, and thus orders to cease such actions are not lawful orders. Consequently, the court found that deputies did not have probable cause to arrest a citizen under California's resisting statute for his failure to comply with orders to stop recording officers, as he was not disobeying a lawful command. Well, given this precedent, it is probable that a court would conclude that Mr. England's arrest was unlawful if it also determines that Officer Hoyt did not have the authority to order Mr. England to step back from the vehicle, which seems likely. However, it should be noted that the right to film in public is not absolute, and courts have consistently held that the right to film the police is subject to reasonable time, place, and manner restrictions. In the 2024 case of DeCastro versus Las Vegas Metropolitan Police Department, the U.S. District Court for the District of Nevada held that Officer Brandon Burke was entitled to qualified immunity in a Fourth Amendment lawsuit filed by a citizen that he arrested for filming a traffic stop, Jose DeCastro. Officer Burke informed Mr. DeCastro that he could continue filming, but ordered him to stand farther back from the traffic stop. Mr. DeCastro backed up about a foot or two, but when Officer Burke ordered him again to step back, Mr. DeCastro refused to step back further, and Officer Burke placed him under arrest. The court determined that Officer Burke was entitled to qualified immunity, meaning that Mr. DeCastro could not bring a civil lawsuit lawsuit against him for any violations of the Fourth Amendment because Mr. DeCastro's lawsuit did not point to, quote-unquote, clearly established law that would have put Officer Burke on notice that arresting Mr. DeCastro would violate the Fourth Amendment. Although Mr. DeCastro referenced the Fordyce case that we discussed earlier in this episode, the court stated that, quote, merely asserting a broad First Amendment right to film police activity in public is not sufficiently specific. DeCastro has not identified a Supreme Court or Ninth Circuit case establishing that a bystander has a right to film from a particular distance, that an officer cannot tell a bystander filming a traffic stop that they must back up, how far the officer can order the person to back up, and that the officer cannot arrest a person who disobeys that directive. The court also argued that, now quoting again, DeCastro also has not pointed to a robust consensus among other courts on the contours of reasonable time, place, and manner restrictions on filming the police in public. Courts vary on how close is too close, and whether the allowable proximity changes based on the context, such as a traffic stop, an arrest in a public place, or near a police checkpoint. Well, accordingly, even though Mr. England would have a strong defense for any resisting or obstruction charges brought against him, if he were to pursue a civil lawsuit against Officer Hoyt, qualified immunity would be a particularly challenging hurdle to clear.
Take a seat right here.
I can't believe you. I don't want to sit down.
I told you to sit down.
I don't have to sit down, though.
I told you to sit down.
Why would I have to sit down?
Now you're under arrest.
How
Get
am
back
I
in my
under
car.
arrest? Gaudier, get this guy under control, please. You know what I was I was recording him while he was in his car. That's nothing. That's not against the law. You should know that. I've already talked to your sergeant.
Actually, sit back up.
I've already talked to your sergeant.
That's cool. Stand right here.
There will be litigation.
Sounds good, man.
Yeah. Good for the city. Because you're wasting tax dollars. Stopping the First Amendment activity.
Explain all that to the judge.
Okay.
Or to your YouTube followers or whoever you want. I don't care. I hope it's worth the YouTube likes.
Yeah, I hope it's worth your
Scott, will you grab that?
And I'd like to speak to your sergeant as well, please.
Cool. You can speak to him when you get out of jail. You can call him.
I'm just getting off work. There's nothing in there. And I have to go to work tomorrow. Just be aware of that.
Yeah, I don't really care about that.
You don't really care about that? Your body camera rolling?
Yeah. See how it's red and blinking?
Wow. Boy. And I have two pins on my chest. Writing pins.
Okay. Thank you for telling me that.
Oh, no problem.
Want to separate your feet for me?
Okay. Three pins.
All right, go ahead and take a seat, sir.
All right.
You can spell all this on the floorboard for me. Bunch of loose coins. Here, let me get a little bag. Thanks, dude.
Good?
Yeah. All right, sir, what's your last name?
England.
England?
Yeah. What am I being charged with?
Obstructing or resisting a peace officer. How do you spell England?
How did I obstruct? What did I obstruct?
Is it spelled like the country?
Yeah. How did I obstruct though? There's no crime scene tape. There's people walking on the sidewalk all around.
What's your first name?
I'm confused by that. Can I speak to your sergeant?
No. What's your date of birth? What's your social?
I didn't even do anything wrong.
What city were you born in?
I did not break the law at all whatsoever. I record you guys all the time.
I don't mind you recording me. As a matter of fact, I think I remember. Were you over when we found the stolen car over on Wells?
No. Stolen cars. No.
I don't mind you recording us. It's when you're in my window when I'm trying to have a private conversation with someone on the phone,
But
and you won't
your
step away
sergeant-
after I told you multiple times to walk away.
But your sergeant
And then when I
already
try and
told-
tell you to sit on the curb and I try and detain you peacefully, and then you refuse to follow my
Well,
commands,
because
that's
I
why
was
you're under arrest.
unlawfully arrested though.
Hey, what's up?
Oh, sir.
No, I'm good.
nothing. I did nothing wrong. In fact, I approached you peacefully and respectfully.
No, you're good. What gentleman? Yes, ma'am. Talk to you later. Bye.
Hey, wait. Can we just start over? If you ask the audience, I've recorded him, and he's very cordial with it.
Yeah, I have no problem with you recording. But just like if you were the press and you came with the camera, I'd have no problem with that. But just like the press, I told you, hey, you need to step back. I can't have you in my face right at my window when I'm trying to have a private conversation. You understand that?
Right.
So I asked you several times to step away, and you said no.
I was wanting to ask you questions.
No, I said, is there something I can help you with? And you said no. Oh, this is actually my car. Blah blah blah. And then I detained you. I detained you in handcuffs. You said it was our car.
Mr. England argues that the police vehicle belongs to the public, since it is paid for by tax funds, and therefore that Officer Hoyt could not make a so-called private call from the vehicle. Now, while the police vehicle is publicly owned in the sense that it's owned by the government, it is important to note that the fact that property belongs to a government entity does not mean that everyday citizens can exercise control over it. Rather, as the Supreme Court explained in the 1966 case of Adderley versus Florida, the government, now quoting, has power to preserve the property under its control for the use to which it is lawfully dedicated. And that, now quoting again, the United States Constitution does not forbid a state to control the use of its own property for its own lawful, non-discriminatory purpose. However, Mr. England does have a valid point about the level of privacy that Officer Hoyt could expect for his phone call, although the issue stems from the fact that he was parked on a public street with his windows down, rather than from the government ownership of the police vehicle. As the U.S. District Court for the District of Nevada explained in the 2013 case of Schmidt versus Furlong, quote, there is no reasonable expectation of privacy in areas open to public observation. Now, while this case, like many others addressing similar issues, centers on whether an officer's actions violated a citizen's Fourth Amendment rights, the common sense principles underlying these cases are equally relevant to Officer Hoyt's conduct. If Officer Hoyt needed his conversation to be private, well, he should have created the privacy necessary to conduct a secure phone call by, at the very least, rolling up the police vehicle windows.
And then I tried to tell you to sit down, which is a lawful command when you're being detained.
Why would you detain me, though? I didn't do anything wrong.
Okay, I'm not going to have this conversation with you.
Well, can we just start over?
No, there's no straight. You're under arrest.
I have to go to work tomorrow. Literally.
You're not going to work now. Look and turn that way so you can put your seatbelt down.
Okay.
Next time you should listen to officers when they warn you. Who's like me to list as next to kin emergency contact for you? Do you want anything other than?
So isn't obstruction like a physical thing?
No.
When there's a crime scene?
It's defined as literally anything that places a delay in the lawful duties of a public officer's, in the duties of the public officer's office, or something along those lines.
You said that you was on a personal phone call.
No, I said a private. That's different.
Private, right. But you're a public officer, so
okay.
A private call will have to be done in the private.
Is this not? My car is considered private. Am I allowed to break into your car and do whatever I want in your car?
This is the public's car, though.
This is not the public's car.
The police car?
That's correct. So do you think that I would arrest somebody if they were to get into my car without my permission? My point is that it doesn't belong to you. It doesn't belong to any random person that walks down the road.
It belongs to us as the public, though.
No, it doesn't.
Yes, it does.
All right, well, you can explain that to the judge.
Okay. I'm surprised you don't know that.
I'm not surprised that you don't.
Although Mr. England was arrested, no criminal charges were ever filed in court. Mr. England told me that he attempted to obtain the arrest report, but he was told by the Reno PD that the encounter was still under investigation. Mr. England also told me that he contacted Lieutenant Ryan Connolly, who informed him that the department had reached a conclusion on the matter, but Officer Hoyt was appealing, and the department did not know when the appeal would be resolved. In September of 2023, Mr. England filed a pro se federal civil lawsuit alleging that Officer Hoyt violated his First and Fourth Amendment rights. However, this dispute was dismissed without prejudice on April 2, 2024, because the pleading did not include sufficient factual allegations to state a legal claim. Mr. England was arrested again on September 18, 2023, for filming Officer Anthony Sotelo. I've included a link to Mr. England's footage of this arrest in the description below. This time, Mr. England was charged with resisting a public officer, and on April 1, 2024, a judge found him guilty after a bench trial. On April 29, 2024, Mr. England appealed his conviction to the district court, and as of the date of writing this episode, the appeal is still pending. Overall, Officer Hoyt gets an F for maintaining an impatient and authoritarian demeanor throughout the encounter, exhibiting a blatant disregard for Mr. England's First Amendment right to film and the Nevada statute protecting citizens' rights to record the police, and failing to exercise discretion and basic common sense. Although this is not the first time that we have encountered an officer with a similar attitude on this channel, it is truly baffling that Officer Hoyt seemed to believe that he could have a private phone call on a public street, and this entire altercation could have been avoided had Officer Hoyt simply rolled up his window to create the privacy he desired. And although I think it is possible, if not probable, that a court would grant Officer Hoyt qualified immunity for his actions, this does not mean that I believe that the arrest was reasonable, justified, or even lawful. Rather, it simply highlights the challenges faced by civil rights plaintiffs in meeting the high standard of proof required to overcome the often insurmountable obstacle of qualified immunity. Mr. England gets an A- because, although he expressed some confusion regarding the public's ownership of the police vehicle, and he refused to comply with several officer orders, he submitted to the arrest while verbally dissenting and requesting a supervisor, and he also took appropriate steps after the arrest to challenge Officer Hoyt's actions. That being said, I do want to caution Mr. England that, as we discussed earlier in this episode, officers are permitted to impose reasonable time, place, and manner restrictions on how and where citizens can film them. Unfortunately, the specific boundaries of what constitutes a quote-unquote reasonable restriction have not been thoroughly litigated, leaving some uncertainty in this area. As the Fifth Circuit Court of Appeals explained in the 2022 case of Bueller versus Deere, quote, "The rub is figuring out when filming veers from documenting to interfering. For example, how far away should a citizen photographer be so as not to get in the way? How close is too close, such that the filming, however well-intentioned, becomes hazardous, diverting officers' attention and impeding their ability to perform their duties in fast-moving, highly charged situations." Now, although I do not believe that Officer Hoyt's restriction was lawful or reasonable in this instance, I do hope that Mr. England understands that future encounters may present situations where refusing to step back from a traffic stop or other officer investigation could lead to a lawful arrest. Given the legal ambiguity surrounding what constitutes a so-called reasonable restriction, it may be prudent to err on the side of compliance with such orders, even if they seem overly restrictive. This approach could mitigate the risk of a criminal conviction if a court ultimately finds the order to be lawful. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to pick up your copy of the Civilian Rights Hand Guide in the links below.